Welcome to Enlightened Wealth Strategies, the podcast where insight and knowledge meet opportunity. Please join us as we navigate the world of finance, discovering actionable strategies to help you achieve your personal financial goals.
With decades of combined experience, we're here to shed light on the topics that matter most to your financial well-being. Whether you're accumulating, preserving, or distributing your wealth, this is the place for you.
Now let's dive in and start your journey to financial enlightenment.
Well, hello there, James. Good afternoon.
Is it afternoon already? How are you, Jim?
I'm doing good. Afternoon. Welcome to another episode of Enlightened Wealth Strategies.
And we have a great topic today.
Fire away. What is it?
Estate planning, just the fundamentals thereof. And it's a topic everyone loves to talk about.
Oh, yes.
I'm being facetious.
I know.
Sarcastic, sardonic, and choose your word.
But it is a topic.
But it is a very important topic, and it's important discipline within financial planning that most advisors, I kind of liken it to, a lot of advisors don't necessarily want to address that out of the box because most people don't want to deal with their mortality, right?
That is correct.
However, you and I could do all the wonderful planning in the world, and God forbid the individual walks outside and gets hit by the proverbial bus, and we didn't do the estate plan.
And that's shame on us.
It is. So what I've learned to do over the many years that we've been doing financial planning is that we really need to address it simultaneously. As we are working through a financial plan, you need to kind of address the estate planning aspect of it, despite the fact that most people don't necessarily want to view it or look at it. It's incumbent upon us as professionals to make sure that individuals do address it. And you can weave it in each of your conversations and discussions and meetings with clients. So today, what I'd like us to do is to actually walk through the basics, which is, as most people know, that there's a will, which is your intent to, upon your passing, basically distribute the assets that you own to your heirs, whether your children or other people or both. Or organizations, perhaps people have a charitable inclination. So having said that, there are other documents as well. We tend to call them ancillary documents, but, for example, durable power of attorney, the healthcare proxy. We may even touch on special needs. So there might be, and it's not necessarily a legal document, but letter of intent. And I think also we need to cover the individuals that are going to step in our place upon passing. So that's executors and possibly trustees. And in some instances, we have to appoint guardians for small children that have not reached the age of majority. And so I think we would like to do is address those so that at least we cover the basics. There are some things that I'd like to cover. Maybe we do it at another date, but when we get into more specifics, we can touch on them, trusts, at least the basics of trusts, how they could work, whether they're inter vivos or testamentary, and we'll get into the definitions of those. I don't want to get too ahead of myself or us, but we do have a guest.
Yes, we do.
And she happens to be an estate planning attorney. There are other legal aspects that she works in, and I'm going to allow her to introduce herself and tell us a little bit about her practice. Not unlike our practice, we delve into different areas in finance and investment management. In the law world, or the world of law, they also have other specialties and expertise that they offer services in as well. So with no further ado, as they say, We have Kimberly Paton, who is an estate planning attorney, and you are located your offices are in Fair Lawn, New Jersey.
Yes.
So please introduce yourself. Let us know a little bit background as I described, and perhaps you could tell us a little bit about what your areas of expertise are, aside from estate planning, which we will talk about today.
Okay. Thank you very much for having me. My name is Kimberly Paton. Paton, just one T, so a little unlike the general, but nobody seems to get that reference anymore. Everybody's getting younger and younger.
So you're not related to the general?
I am not related to
the general?
Oh, I behave like a general, but my office is in Fair Lawn. I am licensed in New Jersey. I've been licensed for 38 years. I've been practicing in private practice for 38 years. I'm also licensed in Florida. I almost said Florida. I'm getting ready to be licensed in Florida. I'm not there yet, but I am licensed in New York. We have some offices in New York also. We have offices down in Toms River also. But most of my practice is in Fair Lawn, Bergen County, Passaic County, Essex County, but we are able to help anybody in New Jersey. I primarily practice in the estate and trust department, which is estate planning, the wills, the living wills, the powers of attorney that you mentioned, trusts, and that is the planning process. The second part of that is the estate administration process when somebody actually passes away and having to transfer the assets in accordance with the will. And hopefully there really is a will, an updated will, an original will. I have clients that don't know where the original will is, so then we wind up going through intestacy anyway. Or on certain occasions, I've been able to probate a copy of the will, but it's a very, very complicated process.
Okay, so you mentioned intestacy.
Mm-hmm.
For the audience, can you explain exactly what that means?
Sure. That's when somebody dies without a will, or even a will that doesn't cover all of their assets. So they don't have a will, they don't have an effective will. Now we look at the statute and say, who inherits from this person? And you can think of it as next of kin. So your next of kin, and it also matters when the person died, because our intestacy law has changed over the years. There was way back before 2005, if I always pick on the man, he dies first. The husband always dies first in my examples. And if he had a wife and children, the wife and children had to split the inheritance. After 2005, the husband died. The wife, assuming it's the old-fashioned marriage, one marriage, children from that same marriage, then the wife got everything.
So that changed after 2005, because
Yes.
it used to be that, as you described, they had to split it.
Yes.
Okay.
Yes. So
Now, is that New Jersey only? What about other neighboring
other
states?
states have similar, they all have intestacy laws.
Correct.
But they have, and I'd have to really do a whole survey, but they're pretty similar to this.
Mm-hmm.
If you don't have a spouse, and here, this is always a big problem for people who are not married, and they're together for 30 years, they're committed, they live as though they're husband and wife, but then when somebody dies without a will, they have to go through intestacy. And oftentimes, it means that the children are inheriting everything. And sometimes it means that these minor children are inheriting everything from the father. And the mother is not necessarily the first person who will be the trustee for these children. Because the father's blood family, his sister, his mother, might have the first right to become the trustee of the administrator for the estate, and then the trustee for the children. And it can cause a lot of family backlash, difficult situation, even though they have been in a committed relationship, even though I've had situations where even when the mother of the children has been embraced by the family as though she's the wife, as though she's the daughter-in-law, when the man dies, there's family discord. And it's not
get
nice.
ugly. Yes.
Exactly.
So what you're basically saying is, and this is one of my questions, is who should have a will?
Everybody should have a will.
And for the reasons you just cited, whether they're married or not, you should have a will. So having said that, you also pointed out that timing So if it's an older will, could it be more easily disputed? Hence, we should be updating. I mean, we as advisors generally tell people you should update it at least every 3 to 5 years.
Mm-hmm.
And more specifically, if there's changes in life events like divorce or a change in job, retirement, changes in the estate tax law, which we are going to address too, because we may be seeing some things coming down the line with the Trump administration.
Mm-hmm.
But going back to my main question, and you seem to answer it, is that everyone should have a will once you reach the age of majority.
Yes. Now, additionally, I wanted to highlight, you mentioned about divorce. If you're getting divorced, you should change your will. You don't wait to be divorced, because in New Jersey, we don't really have legal separation. You are married until you are divorced. That means that if you don't have an updated will, or if you die intestacy, your spouse is probably your next of kin. So the spouse that you're about to divorce will inherit everything.
However, here's the however. That's great advice, and it should be heated. Not heated like hot.
No, we want to try to cool everything down. Too much emotion already.
The other heated word. But the importance of it is, as you described, God forbid, the husband wants to. We'll use the husband. We
always use the husband.
Right, he happens to pass away prematurely. He didn't change his will. Everything's going to go to his future, should have been his future ex-wife.
Correct.
He didn't put that in play. However, now let's assume he doesn't die. You have this individual as a client. You change the will, but there's other components that cannot be changed until he is divorced. And one of them would be if he's working for a company and has a 401k plan. You can change that until you are divorced, correct?
That is absolutely correct.
Okay.
Yes.
Are there other assets?
And that's a very good point, because there are certain assets that are not controlled by a will.
Mm-hmm.
Those are what we call the non-probate assets.
And that's when we need to get into, when we won't quite yet, but we will address it, is the importance of having beneficiary designations on those assets that do pass outside of the will.
Correct.
Like a 401k plan, like a life insurance policy.
But you can change the beneficiary on the life insurance.
Yes.
Even if you're not officially divorced.
Well, with the exception being a group policy that you're working for a company.
There's exceptions.
So there's exceptions to everything,
but
yes.
If you're in the process of divorce, you want to change your beneficiaries, as many beneficiaries as you can legally, and you want to change your will. Now, we also have what's called an elective share. So depending on the facts, if you're in this process of getting divorced, but you're not divorced yet, it's possible that even if I change the will to say everything goes to the children and not my spouse, the spouse might have a right to take certain amounts of money from the estate anyway. That's the elective share. It's designed to make sure that the spouse is never left destitute.
Mm-hmm.
But it's a very complicated formula, too complicated for today's presentation, but it's out there. So there are times. There's also times where once you are divorced, even if you forget to change your beneficiary in life insurance, our law says it's automatically changed. I don't rely on that, because insurance companies don't want to follow that. No. They're worried about being sued.
Of course. All right. So with the will, let's talk about the components or the provisions that the fundamentals or the basic provisions that you would want to incorporate into the average person's will. When I'm going to get into more sophisticated planning.
You did a great overview already. Okay. You want to say who is going to inherit if I die? Who gets what? Now, if you have something very specific that you want your shore house to go to your son, you want to say that specifically. You also want to say, and if my son has predeceased me, who gets it after that? So you want a contingency plan, because as much as we like our people to update their wills, they don't. And anything can happen. So we always have a contingency plan. What happens if that house doesn't go to my son? What happens if my co-op in Hoboken, which I left to my daughter, and she's not around? So if you have something specific like that, that's great. Most people don't. Most people just say, if I die, everything goes to my spouse. If we both die, everything goes to the children equally, without being very specific. You don't have to be specific, but sometimes people really, really care. I also put always in my will a paragraph that says, and I might update this just by writing a letter. That has to be only for personal property. My jewelry, I might say, goes to my daughter, and then I have a granddaughter, I change that letter. So I can do that in New Jersey.
So within the will, you make reference to that letter.
Yes.
And it's
yes.
outside. It's
not, I don't have to update the will. You don't have to keep coming back to me.
It's an attachment.
It's an attachment.
Okay.
But you have to make sure your executor knows where that is so it can be enforced.
But it's stated that it exists in the will. So they need to know that it does exist.
It could exist. If you can't find it in 4 months in my documents, then you can assume that I didn't write it.
Oh, so you give an out.
I do.
Okay.
I do.
Okay. That's important.
So you always want the contingency plan. You also want to remember that this will only covers probate assets, things that are in your name alone without a direct beneficiary, as opposed to those non-probate assets. So you might be thinking, everything I have is going to my husband, but all of my assets name my children as direct beneficiaries.
Okay, I'm gonna bring you back.
Okay.
Just because I'm not sure who will be watching and listening to our podcast. So we know what probate means, but maybe they don't. So what does that mean, and what is the process of probate? So
probate in New Jersey is very good. So when you hear that you need a revocable trust to avoid probate, I don't recommend it for New Jersey.
So probate means to prove, correct?
You're proving the will. Here, you submit the will to the surrogate court in the county in which the person was domiciled. And typically, it's a pretty straightforward process. You submit that along with a death certificate, an original death certificate, some information, and it gets processed. And you sign some papers as the executor. You promise to be the best executor you can be. And then you get proof that you are the executor. And that's usually called letters testamentary or surrogate certificate.
Right.
So now you have proof. Now, we as the attorneys would get an EIN number for the estate. It's like a social security number for the estate. Now the executor can go to the banks with the proof that they are the executor, that letter's testamentary. They can open an estate account, and then they start collecting all the assets. Now, this is called the administration part.
That's correct.
The probate is simply going to court.
So we've so far covered putting the wills together, probating through the court as the executor, and then you've also touched on the estate administration. Before we even do that, within the will itself, we could be setting up trusts,
yes.
Testamentary trusts.
I love trusts.
I know you do.
I don't necessarily love the revocable trust because I think in New Jersey, you're not getting any great benefit from it. Now, some families, it does help.
Well, to that point, let's cover that, because a lot of people say, "Well, I like Florida. I want to be a resident of Florida because, well, they don't have a state tax,
right.
Unlike New York, New Jersey, and Connecticut, which is where we predominantly know."
Right.
But they have to go through probate there, do they not?
Wherever you're domiciled, where do you call home? You probate.
Okay.
If you have property in New Jersey also, so you're living in Florida.
Yeah, but my line of questioning had to do with the fact that people get revocable trusts and they pour everything in.
Correct.
In lieu of a will.
So, yes, they try to do that.
But that's what you don't like.
But what I don't like about it is in New Jersey, probate is very straightforward. Our surrogate courts are wonderful. They're very helpful. A revocable trust is considered a disregarded entity. So you're not getting any protection from
There's no tax benefit either.
There's no tax benefit.
Right.
There's no protection. You're incurring extra expenses up front for nothing. For the average person, I continue to say, if you are in a different fact pattern, like you just described, I live in Florida and I have my house here still in New Jersey and I go back and forth. Well, now I'm going to have to probate in Florida, which is a harder probate state. So you should have a revocable trust in Florida. And if I already have a revocable trust, then I might as well put my New Jersey property into it also. And you have to change the deed for that. And that's why I say if you don't have if you're not living in Florida, then you just wait to probate the will, because people will put a house into a revocable trust in New Jersey expecting to avoid probate. That costs money. It costs money to create the trust. It costs money to move the house into the trust. They might sell that house. So now you really got no benefit from that trust. And you paid upfront. And it's not so hard to probate in New Jersey. Now, there are times where it does make sense in New Jersey. And that might be what we just described. I live in a different state. I have property here in New Jersey. I live here, but I have property in New York, another hard probate state. So I would create a revocable trust for that. Sometimes it is, a blended family. So now we have the couple who has children from prior relationships, and now we want to make sure that the house, which is often the biggest asset anybody has, can be used by the surviving spouse for the rest of their life and then get split between the two families. So that's where a revocable trust can be very, very effective, because the couple maintains control over it, and then they know that it'll be split among their children the way they set forth. Okay. You can do that in a will too, but it's a little harder.
All right, so let's then cover what most people are concerned about and want to make sure that they have addressed within their will is federal estate taxes.
Okay.
And I think they're going to learn through this discussion that for the most part, most of the general population probably won't be subjected to estate taxes.
Probably.
Maybe you could explain to us what the current exemption is. And just moments ago, before we started this offline, that there's now a proposal in front of Congress by a couple of Republican congressmen that they want to permanently set the federal tax exemption at $15 million. So maybe we can get into the history of the personal estate tax exemption, where it was, where it is, where it could go at the end of the year if things don't change. You know exactly what I'm speaking of.
So way back when I started 38 years ago, the exemption was about $600,000.
That's right.
Then it went up, and it went up $2 million at some point. It went away in 2010. Which is not as good as it sounded.
For only that year.
For only that year.
Yeah.
So it's not as good as it sounded, because taxes are like a big fruit salad. You've got estate taxes, income taxes, capital gains taxes, and they all affect each other. So
and you got to die in that year. So
you have to die in that year, like George Steinbrenner.
Yes, that's exactly right. There was somebody, and he was it. He planned it beautifully.
Here's your estate plan.
So everyone understands, he died in that year where there was no estate tax.
Right.
And being a wealthy person, he was not
huge
subject.
Amounts of estate taxes.
So his children and heirs and maybe organizations, wherever there was no estate tax. Right. And estate tax at that time was very high. It was 45%, right? Yeah. The tax rate.
Now, one of the things they lost because of that was you don't get the step up in basis of capital gains taxes. So, and many people understand the concept. They may not know the name is step up in basis, but if, like, my parents bought their house for $20,000, 65 years later, it's worth $500,000. They hold on to it until they die, and they leave it to the children. The children take it as though we paid $500,000 for it. So that's called a step up in basis. And that saves a lot of capital gains taxes. So for the average person like my parents, if they had died in 2010, they never had to worry about estate taxes to begin with. And now they don't get that step up in basis.
Right.
So as I said, it's not as good as it sounds. I'm sure Steinbrenner has the ability to use many, many sophisticated tax plans, and his family know, and they have, so they're okay. We're not crying for the Steinbrenner family, but it does make a difference. So even though we have an estate tax right now of $13.9 million exemption per person, so a couple now has closer to a $27 million exemption.
And that was due to the Tax Creation and Jobs Act of 2017, the
Correct.
exemption. So
Correct.
where did that start? And then it got indexed
started
to?
at, now you have to help me out here.
Was it 11?
I think it was 11. It went from 11 and then
now it's almost
gets
at
indexed
14.
up. Right. And if this does not go through this new law, next year it will go down to index for 5 million, but I think now it's really considered about 7 million. So
due to the
still,
indexing.
because of the indexing.
Right.
So still, for the average person, we don't have to worry about estate taxes. Having that estate tax is wonderful because it allows for the step up in basis of what somebody bought stock early in their career. Maybe they got stock options with Pepsi or Coca-Cola
Amazon or
anything
Apple,
like that.
Right.
They've held on to it for 40 years, and now to sell it is a huge capital gains tax.
Mm-hmm.
So this is why I say most people know this concept.
Mm-hmm.
It's I'm always so impressed that they know the concept, they don't know the name. And that's why having
Or
these
they
state
don't know the
taxes go.
mechanics behind it, which is understandable because that's not what they do.
Most of the time, most of the people are going to avoid the estate tax, the Fed.
The federal, it's the
the
state is the other issue.
We're very lucky in New Jersey. They eliminated the estate tax in New Jersey in 2018. So we don't have an estate tax. And the difference between the estate tax and what we do have, which is an inheritance tax. The estate tax says, how much money does this person have when they died?
Mm-hmm.
And that includes those probate assets that we've talked about that are controlled under the will and the non-probate assets. So you add them all up to be the taxable assets. If they're over a certain amount of money, then you pay taxes. In New Jersey, we eliminated that. We do have an inheritance tax, and people get tripped up with this a lot because the inheritance tax says they don't care how much you're leaving somebody. It says, who are you leaving it to?
Yep.
So if I'm leaving it to what they call a Class A beneficiary, my spouse, my parents, my children, my grandchildren, there's a 0% tax. And that wasn't always the case either.
No.
But then if I'm leaving it to my sister, the first $25,000 is exempt. And after that, it's an 11%. If I'm leaving it to a person I've been living with as though he's been my husband for 30 years, but we're never legally married, 15% inheritance tax. And that's one of those things that get tripped up because people feel like they're a couple. They feel like they should get the unlimited exemption because as a spouse, you don't have to pay.
And they're viewed as common law spouse too.
Well, they're not legally.
No.
We don't have a common law marriage here in New Jersey. So it is, and there's more to that also. It's not like just living together for 7 years, which is the old way. Now we don't have it. And for that reason, people get hit with taxes that they're not expecting. I've had it happen where people will leave. So I have clients that are never married, no children, but they think of their nieces and nephews as their children. And they don't want to pay for a will, so they just put on all of their beneficiary designations. This money is going to my 3 nephews. And now, so therefore, no attorney is consulted, no accountant is consulted because it's below the $13 million. All right. They forgot about the New Jersey transfer inheritance taxes, or they never knew about it. That's a 15% tax. New Jersey catches up with that in about 3 years. Mm-hmm. So now 3 years later, you're getting a bill. And what New Jersey does is actually pretty funny because they just make up a number. They say, you owe $247,213.17.
Now you got to prove them wrong.
Right. But it's just designed. It's just a crazy number. And it's designed to get you to say, hey, what is this? And but wait, I inherited $100,000. How could this be true? Well, it's not true, but it means you call me up and you say, what is this all about? Well, you have to pay inheritance taxes. No, I don't because I'm below the exemption. No, New Jersey has inheritance taxes. So now we pay it. And there's an interest to it also.
So how could that aunt have avoided giving her nephews that directly? Could she have put it in a trust for them?
She could have put it into an irrevocable trust. So we've been talking about revocable trust, irrevocable trust, but she's giving away her money now and she doesn't know if she might need it. So it's a hard thing to do. She puts it into an irrevocable trust. She lives another 3 years. And after 3 years, if she dies, the nephews would get the money from the trust without New Jersey inheritance taxes.
Now, there's no way in her will to have lived off those assets, and then upon her passing, it passes to the trust for their benefit?
Not to avoid inheritance taxes.
Okay.
You can do that, but you're having the inheritance
You're still
taxes.
doing, okay.
Now, people will use an irrevocable trust for this tax savings purpose, which is a great purpose, and it's all legal. There's no evasion here. We are avoiding taxes. People who have great wealth use irrevocable trusts all the time to help avoid estate taxes, because we are allowed to gift away. Right now, you could gift away $13 million and you wouldn't have to pay gift taxes. Now, if you put that into an irrevocable trust now, and by the time you die, it's worth $20 million, your family is getting $20 million without any estate taxes. And
because the appreciation on that has been you avoid the estate tax on that appreciation.
On all the appreciation. And the government is not coming back to say, well, wait a minute, we reduced the amount of the estate tax by the time you died. That was the clawback that everybody was talking about a few years ago. But that's not going to happen now, because they say no clawback.
Yeah, it's not part of this existing law.
Exactly. So going back to your original question, the amount of the exemption has increased over time. We as attorneys and accountants and financial advisors have come up with techniques to how to use the tax law to protect families from paying extra unnecessary taxes, but they do have to give up something, like giving up ownership of an asset and putting it into an irrevocable trust. Over time, it's increased. Everybody's been worried about the exemption reducing, because it will affect more people. But now with this proposal, Congress is proposing that?
Yes.
So $15 million exemption, quote unquote, permanently, because we know nothing's permanent in our laws.
No.
They can change it.
Oh, yeah, it's permanent, but it's never permanent.
Yeah.
That's just a word.
I know. So that will, of people avoiding estate taxes. Unfortunately, I think it is a possibility that more people, because they don't have to worry about estate taxes, will be hit with the inheritance taxes because they're not talking about it.
Exactly.
They're not worried about it. They're doing the direct beneficiaries because I just don't want to pay for a will, which is not, that's fine. Why I like having the will, even if we could avoid it with direct beneficiaries, is because I told you, I love trusts in a will. So I have in my will a lifetime trust for my children. So my money will go to my children equally in a trust. My son will be trustee for his own trust. I have to put a little bit of restrictions there. But if he gets divorced, if he gets sued, if he goes bankrupt, as long as he's followed all the rules, nobody can take that money away from him.
So it's protected.
It's protected. And that's another purpose of trusts.
Mm-hmm.
But I'm not ready to give away my money yet either.
So does that fall under the umbrella of the term asset protection?
It is asset protection, but for my children. It's not for me.
Well, exactly. It's the assets you've accumulated, and now you want to pass it on to your son and daughter.
Mm-hmm.
But you also want to prevent them from winding up in a situation, for example, a divorce where it becomes mixed marital assets.
Correct.
And then subject to being lost, which was not your intent, that 50% of your wealth would go to your former daughter-in-law when you're not here.
Exactly. And that's why I like this trust. And I remember starting out 38 years ago, and people would say, "Oh no, my son can take it at 18," because I would be pushing these kind of trusts and saying, "How about we just wait until he's 25?" No, 18 will be fine. 18.
They still can't tie their shoes at 18.
Yeah.
And so that goes to the other point too. So when you set up a trust like this, Jim and I are, I think we're a little familiar with the sprinkling provision. Mm-hmm. So perhaps we could talk a little bit about that for a few minutes.
Sure.
Because it allows a family, rather than having the child get it at 18, the age of majority, they can sprinkle it out over different ages, or
And what's the maximum age at this point?
as old as they want it to be.
Okay.
Yeah.
Lifetime.
Okay.
Yeah.
That's my trust. It's a lifetime trust.
And and you can also incorporate any types of provisions. So I want to piggyback this.
Sure.
You can put any kind of language that within those provisions to prevent or incentivize your children to do certain things or not to do certain things. So it's behavioral. Correct?
It is. And this is part of what I love about trust. They are very, very flexible. So people don't recognize how flexible they are, what you can put in, what provisions are you allowed to put in.
So you can almost say, you inherit this money, but you're not allowed to buy a sports car over $100,000 with this money. Right?
Yes.
Or you need to get your master's degree. Or you cannot do any kind of drug or alcohol abuse, substance abuse. And if you do, your trustee is not going to distribute these dollars to you.
Correct. You know what I can't say?
No.
I can't say, you don't get any of this money until you divorce that girl.
Oh, yes. Okay. I knew you were going down that
path. And you can't say, okay, I'm leaving this to you. But if you get married, you can't get anything. So there are certain things that we're not allowed to try to control.
There's exceptions to every rule.
Right.
But it's pretty broad.
It is very broad. And if you can come up with a good enough reason within the trust to justify why, it's not just that I don't like my daughter-in-law, it's because she is destroying my son, taking full advantage of his finances, and I need to protect the money for him. You know, that has passed muster.
Okay.
But certain things you can't do. But you can do, like you said, almost everything else. I can say, okay, and this is the sprinkling provision. Okay, it's staying in trust until he's 50, but at 25, he'll get 10% of the trust. At 30, he gets another 10%, 35, another 10%. So you see it's sprinkling out. And at 50, he gets the rest of it. God forbid he dies before 50. The trust now says it goes to his children. That's what my trust would say. It goes to his children, not his wife. It can be used for the children for their health, education, maintenance, and support. The mother can be the trustee. She can be using it for everything of taking care of the children, but it's not her money.
Who's overseeing the trust?
This is a tough one because basically nobody. In general, nobody is overseeing the trust unless you put in a trust protector. So I could say this is going into trust for my son and for my son's children for the future. And I could say, and my daughter is the trust protector. So she has a right to watch and see what is my daughter-in-law doing for the children. But that would be also, even when you have that, you have to recognize you're putting into a family dynamic that could be very, very negative and very toxic. So it's a very difficult situation. Some people will use a professional trustee, an institution that's a trustee. You lose a lot of flexibility when a company is serving as trustee.
Well, isn't that also when you could have a family member be co-trustee
you can.
With the corporate trustee?
Yes, you can. But still, the corporate trustee is running it, and they have their fiduciary responsibilities to my son, who is called the lifetime beneficiary, and my grandchildren, who are called the remaindermen.
Mm-hmm.
And you can see that everything they give to my son is taking away from my grandchildren. And now a trustee has a conflict. Am I supposed to give it to him, or am I supposed to save it for them?
You got to preserve the trust for the grandchildren.
Right.
But what was the intent of, the grantor?
Right. And I usually write that in. Typically, I write in my intent is to take care of my son. And I don't want the trustee, so this gives a lot of maximum flexibility. I don't want the trustee to worry about what other assets he has or whatever income he has.
So you're lifting the restrictions by doing that.
I am.
Okay, that makes sense. So now we've spoken about moving assets into a trust for the benefit of children. What about spouses? The testamentary trust is the typical one, but talk about that and then other types of spousal trusts as well.
So there's a number of different spousal trusts. There is what's called the credit shelter trust, marital trust, AB trust. Disclaimer trust works exactly the same. So you can see why this has become such a complicated area. They have the same name for the same document, but it's designed to say, when I die, I'm taking what I'm allowed to give my children, my $13 million, and I'm putting it into a trust for my children, but my husband has the right to use it for the rest of his life. That's a credit shelter trust. That means that money will be protected. I know he's protected, but it'll be protected from estate taxes. So that's driven by saving estate taxes typically. There's a QTIP trust, Qualified Terminable Interest Property Trust. That is usually where it's deferring taxes. It's not avoiding taxes.
Okay. With that trust, wasn't it typically used for divorced spouses?
Yes. More for that. Remarriage. So I'm doing this to my second husband. He can use this money, and I actually have to make him take the income out of there at least quarterly. He can use that money, but when he dies, that'll go to my children.
Correct. Okay.
So it's another way of protecting. It's deferring taxes, but it's also protecting my children that they're going to inherit for the future.
But I still want to.
But I want to protect my second husband also.
Upon their passing.
Right.
Okay. So you mentioned disclaimer. Why would anyone want to disclaim, which means not to accept an inheritance?
For a couple of different reasons. Typically, it's to save estate taxes. And we may not know because the tax law changes so regularly. We don't know if we're going to have to worry about paying estate taxes. So I put in that says everything is going to my husband, but he has a right to disclaim it. So when I die, he has the right to look at the tax law, look at the assets that we have, see will there really be a tax problem for my children when we both die, and then how does he feel about it? Because it's all in his control that he would say, okay, I'm going to put some money. I'm not going to put $13 million in. I'll put $2 million in. I'll put, so he gets to disclaim. He doesn't have to, it's not an all or nothing, but it does give him the control to say, should I do this? Do I want to do it? And that's why people will do it typically. Sometimes you just don't want the asset. Sometimes, the will hasn't been updated in so long that this doesn't happen a lot, but it could. And it has in my practice. Mom and dad did not mean really for you to be getting this much. So I'm going to disclaim it, at that when maybe I was the only child. And this is not a perfect example, but it's for illustration. The will says everything comes to me from mom and dad, but then they had 2 more kids. They didn't mean that to happen. So you disclaim 2/3. Okay. So everybody gets 1/3.
And that was because the will was not updated after the kids were born.
Yes.
Right. Okay.
Yes.
Okay. So we've talked a lot about the development and creation of the will, utilization of trusts. Mm-hmm. And I know I've asked you this question before.
Yes.
When people own real estate, whether they own it as a primary residence, a secondary home, or it's a hybrid, or even an investment property, what are the pros and cons of putting that home into an LLC and or a trust? And why would they do that? Why would it be beneficial? Why would it not? Why would it be detrimental or difficult?
Okay, so it will depend on the type of house that you have. If you have your residence, your primary residence, you don't want to put that into an LLC because you're losing the benefits that you have as an owner of a home, as a homeowner, the tax benefits. There are tax benefits. If you own your home, you get deduct your real estate taxes off your income taxes. If you qualify for the anchor program, which most people should qualify for this if you're 65 years old, because the income limit right now is $500,000. So you can get deductions on your real estate taxes. There's the anchor program, the senior freeze, and there's a new one coming in New Jersey, senior stay. So If you take your home and you put it into an irrevocable trust,
You lose all
you're
that.
going to lose it.
Okay.
If you put it into an LLC, you lose that. And there's some qualifications here I'll get to. If I have an investment property, I absolutely should have it in an LLC. Because if I have somebody going into my shore house, and they slip and fall and they do something very stupid, they're still going to sue me. And if they can sue me for enough, if it's not in the LLC, they can take my house, the shore house, and they can take my house up here in Bergen County. So you put the LLC, you've limited your potential liability. So you should do that with and really the gold standard is if I have 4 investment properties, I should have 4 LLCs, 1 in each.
So that they all don't get sued and lost.
Exactly,
Right.
exactly.
Okay.
If I am worried now because I'm getting older, or I can take with my husband, he got sick, we didn't know what to expect. We did take our home and put it into an irrevocable trust. So we gave it away, but we did it a special way. On the deed, I kept a life estate. That's a legal right for us to continue to live in the house. What that does? From a tax point of view, it protects all those benefits, almost all the benefits of being a homeowner. From an asset protection, I'm protecting the asset also. The one benefit I lose, because we did talk about a step up in basis,
Yes.
I keep that. As long as we still own the house when we die, we still get the step up in basis. I guess this is federal. Federal law says if I sell my primary residence while I'm alive, I get a $250,000 exclusion on the capital gains. So I'm going to save about $50,000 of capital gains taxes. You have 2 people selling the house, like my parents' house, a perfect example. They will have about a $500,000 gain if they sell it while they're both alive. They won't pay any capital gains taxes. If they put that into the irrevocable trust, they'll pay about $100,000 of capital gains taxes. And
Because they will lose that. Yeah.
They'll lose that benefit. Capital gains taxes are so complicated.
I know. But what you just described is that $500,000 gain now is subjected to approximately 20% in capital gains for federal purposes, hence the $100,000 that you mentioned.
Exactly.
Okay.
So those are the reasons. That's why it's very complicated. You really need to see everything. I always say it's a fruit salad. You have to look at everything, and ultimately, what is your goal?
Yeah. So when you and I have worked together, one of the things that I as a planner, I feel responsible to do to help you with your job. Mm-hmm. Granted, we come to you and say, we would like to do X, Y, and Z, but we want to use your legal mind too. But you also need to know what they have.
Right.
So I provide you with a net worth statement, an ownership analysis, and then we also look at the beneficiary designation on those other assets that are going to move outside of the will.
Right.
And we may have to change those.
Right.
But that allows you to do the proper estate planning,
Right.
despite the fact that I may say to you, I think we need A, B, and C. And you could say to me, well, James, yes, you need A, B, and C, but I think you need to consider D and maybe G as well.
Right. Right. And that's what a good estate planning attorney does, is to look at everything. And you definitely make my job easier when I'm working with you, because when clients come in, their first thing is, no, we don't have that much. You don't have that much. Okay. Do you have this? And you start going down a list and, oh yeah. And then you find out they have quite a bit of money that they want to protect. They have a family dynamic that needs to be protected. You know, there's a lot of people with special needs children that need to protect those special needs children, which is a whole different trust.
Correct.
That we would use for them. They have their parents that they're still taking care of, and we need to make sure that the parents are taken care of. So we set up as many contingencies as we need to do for every person. So even a simple will, or basic will, it's not simple.
It's not so simple.
It's not simple.
But it's the term that we use. So we've talked about, yes, simple basic will, and we've expanded upon it moving along. Even individuals that have, and I say that even individuals that have maybe less than $500,000, but when you factor in, as you described, your parents bought their house at $20,000. My parents did the same thing.
Right.
And with inflation, it's probably more inflation factor than value, that the homes are worth much more. But it's not doesn't take long for them to push up to and even exceed $1 million.
Right.
Whereas, back in the 50s and 60s, being a millionaire was very difficult to achieve.
Right.
Now, because of the value of homes, you add life insurance, you add in a few, brokerage accounts, a lot other assets, maybe that second home.
This day and age, almost the guy next door has $1 million.
Yeah. So it's just
The Millionaire Next Door. Remember that was such a big
thing.
novel?
Yeah.
Big deal back in
But that's
80s,
not the case anymore. Just look at what it costs to purchase a car.
Right.
When we were kids, a car was, $1,000, a couple $1,000.
$500.
Now a brand new car you can't get a brand new car for less than $30,000 unless you want a Flintstone car. So it makes it very challenging, right?
You're dating yourself with that comment.
I don't want to date myself. Rather a lady. Okay, so let's cover some of the ancillary documents because that's that's a big chunk of this, even though they're smaller documents. But I would like for us to address the importance of having them in play. It's great to have the will in play, but if you don't have these other documents in play,
that's right.
It's really going to be difficult for family members to manage and or do the estate administration. Is that correct?
Exactly. So everybody should have, absolutely anybody over 18 should have a financial power of attorney and a healthcare power of attorney, also called the healthcare proxy. Because without that, once you turn 18, so we all have our children, we're all still paying for our children into their 20s and hopefully not 30s, but so you feel like you're still the parent. But the reality is once that child turns 18, legally they are an adult. And God forbid they have an accident of any sort, doctors are legally not allowed to talk to you. Will they talk to you? They might, but it all depends on who the doctor is. So you want that healthcare proxy first and foremost. You also want a financial power of attorney when they turn 18 because they'll sign it at 18 and it'll be valid forever, basically, until they get married and have children and then they do their own planning. So because anything can happen in between 18, it's not necessarily just a healthcare risk. It's maybe a healthcare risk, and now we need to access their funds to help pay for the bills or talk to the insurances. And
so when you put that, just going back to that, the healthcare proxy, the financial power of attorney, durable power of attorney, if you're sending your kid off to college, you want to put those into existence.
Yes.
You want to have them signed.
Right.
Because we've heard of the horror stories where a kid winds up in the hospital, they're age 19, his parents come and they want to talk to the doctor, so can't talk to you.
They're not allowed to.
But if they show proof that they are the power of attorney on their behalf,
correct,
although they are their parents too, they have to speak with them.
They have to.
How long is that in play?
It's until they change it.
Until they change it.
Right.
Okay.
I mean,
there's no limit.
No. There's some restrictions on it, and the older a document gets, the more questioned it is. But generally speaking, it's you really only want this until they have somebody else in their life.
The court can't say, oh no, even though they're 27 and they're living alone, they didn't change it. It's still valid.
Okay. It's still valid. And, we talked about, and I'm just going to go back to the will for a moment. We talked about the idea that we want to update our wills and don't have old wills. But as people get older and they become vulnerable, if they change their will too close to their death, they become questionable also. So you really, unless you're fine tuning it.
They're questioned because of their mental
acuity, because their daughter, who is the power of attorney, all of a sudden is inheriting the whole house and the son is getting nothing or, getting a very limited amount. And there are certainly times where mom really does want daughter to get the house because she was the one that's been taking care of mom for all these years. But all of a sudden you're in court fighting over it. So if it's just a balance. You want to have the balance. The power of attorney also gives a person a fiduciary obligation to do what's best for mom. Mom is naming the daughter as the power of attorney or spouse to spouse. But it is a really, really important document. It is the ones that I prepare are valid as soon as you sign them. So everybody thinks that they only become valid if I become incapacitated or disabled. But that's too hard to use in this day and age. So we used to do them. They're called springing powers of attorney.
Right.
But not anymore. We do them. They are legally valid the moment you sign them.
So they don't exist anymore, the spring powers?
Not in my office.
Okay.
And I haven't really seen one in a long time in somebody else.
Can you combine both of the durable powers of attorney?
Yes.
Into one document?
Into one document. I like doing that. If you're naming the same person, if I'm naming my daughter first and then my son second, then I can do it.
So you can. So to that point, you can have one individual be the financial durable power of attorney and one for health.
Exactly.
So
yes.
You can have two different individuals.
Or I can even say my daughter and or my son on both of them. And then I really put them into one document.
Okay.
Because I trust both of them. I think they both can work together. I know they'll defer to each other and they'll delegate to their strengths.
That brings me to a question. Unfortunately, it's funny. The longer you're in this business, the more you see.
Yes.
Oh, yes.
I have a client who sent me her document, and in her document, they're listing both kids, which I think is great. But then somebody brought to my attention, what happens if they disagree?
That's why I qualified it if they can get along. But I do always put a conflict resolution in my documents that says...
That's so important.
Well, mine is pretty objective because I'll say, I recognize my children are reasonable and they can still disagree. And I basically trust both of them to make good decisions. So just flip a coin. And whoever wins the coin toss gets to make that decision.
So we don't have much time. So I wanted to address the other individuals that we appoint within these documents, executors, trustees, and guardians.
Right.
So if you can give us a little bit of a snapshot of each one of those.
So the executor is in charge of your estate after you die and only the probate assets. They marshal all the assets. They bring them all together. They pay any outstanding bills. They file any taxes that have to be filed. Maybe you owe some income taxes. Maybe there's inheritance taxes. Maybe there's federal estate taxes. And then they hand over the money or the assets, as you said, that you wanted it to go to. So they might simply go to your son and daughter outright, 50-50. It might say, I want a trust. So now you're handing it over to the trustee. I named my sister to be the trustee for my children, pretend. So they're handing it over to the sister. Executor is done with their job. Trustee takes over and handles the money for the children and follows the rules of the trust that I created in the will, which is called a testamentary trust. Last will and testament, testamentary trust. And she follows all the rules that I said in there and the sprinkling provisions and the no, you can't have that car and everything else. The guardian, most people think of it for minor children, but if you have a disabled child or disabled parent that you want that needs to be taken care of, you want to name guardians for that person also. If you have a court-appointed guardianship for an adult child or parent, it's probably good to also add your brother on as a co-guardian at some point, or your husband, your oldest son, as a co-guardian, so there's no transition, and it makes life a little bit easier.
And that's because there, as you described, there's really all forms of guardianship. There's 3 or 4 different types, correct?
Yes. And the next document would be the power of attorney. That's called an agent. So, and everybody calls him POA. He's my POA. It's really your pet agent under your POA. So you always want to have backups. And the moment you think that person is not going to do what you would like, you change your document. And I don't like to just say, oh, you think they might steal from you, because it's not necessarily they're going to steal from you, which they could under the document. But it's that my son is a very aggressive investor. So he's not my power of attorney. My daughter is, because she's much more...
she's more conservative.
She's more conservative, and she's more in line with my thinking. And my son doesn't even want to be the power of attorney.
Well, that 2 things there. So what you're saying is you have to appoint primary,
right?
Executors, trustees, guardians.
Yes.
Contingent if they can't serve, or
yes,
they need to be replaced for whatever the reason. And then tertiary, which would be the third
If you
choice.
can get that far, that's fabulous.
Well, that's what you would
Yes.
prefer
I
as
would
an
prefer
attorney.
that.
When you tell people, sometimes they have a real challenge even naming
That's
one
right.
and two, never
That's
mind
right.
three, but that would be ideal is what
Correct.
you're saying.
That's right.
Okay.
Right. And can I just touch on that living will? So that's the end of
Yes,
life decisions. You have a horrible car accident. 2 doctors say you'll never get better, but they can keep you alive on a machine. You really owe it to your family to tell them what you would want. And we also kind of waffle it a bit to say, well, I want this. And you can say, I want to be kept alive no matter what. Or you can say, no, I don't want to be kept alive. And you then can say about your agent, they have to do what I said, or I'm giving them discretion. I want them to be really, really sure that there's really no chance of recovery, and then enforce whatever they think is appropriate.
Okay. With executors and trustees, final thing, you mentioned it. You want some people to be aligned in your philosophy and thinking, but there is also differences from business aspect too, because you have a trustee, they have trust. The word trust itself means that they have to be trustworthy, reliable.
Correct.
They have to have maybe some business acumen, maybe in accounting or finance. That would be ideal too, if it's not required. But those are the types of characteristics and attributes that you are, in fact, looking for in the trustee, and certainly to a degree in the guardians and executors as well.
Right. You would really love to have somebody that thinks a lot like you, so that you're not leaving too many instructions. I don't have to say, don't let them buy $100,000 car, because my sister, who was my trustee when the children were young, there's no way she would have allowed that.
Right. So in summary, what are the 3 primary points that we should make when we think about estate planning and we are going to do this either for the first time or because someone out there has not updated it in a long time?
Right. You want to make sure that you're thinking about all your assets, and are they automatically going to somebody else? If you have a joint account with your sister, it will go to your sister, even if your will says it's going to my children. You want to think about contingencies, what could happen. So we all hate, like you started off with, nobody likes to think that they might get sick or die, but you have to really force yourself to do it. And then you have to really force yourself to think about it every 5 years, every 3 years, any major change in your life. Children move away, children get older. So I named my sister in everything. Oh, I named my one sister for everything. I have 3 sisters. She is the one that's most aligned with me. So I could name her in my will, in my power of attorney, in my living will, which I did. But now the children are older. So that's a good change. My sister doesn't have to be burdened with all of this. Although I did leave her on the living will because my children are in their mid-20s.
Plus, you don't want your sister to get mad at you.
No. So really it is always staying in touch with people, and I think as we get older, the children should never be expecting that this is their inheritance and this is their retirement plan. My money going to them. And I see that regularly enough. But if I am going to leave my house to my daughter because she is taking care of me, I should tell that to my son so that he's not caught off guard, because that's where a lot of the family discord comes in. He's thinking, and my son actually just said to me recently, just promise me it's always 50-50. I said, no, I'm not promising that. You be good to me.
It's never 50-50. It's equitable, but not equal.
Right. And that's it for another podcast, because we have to start talking about business succession planning.
And amongst other things.
Yes.
All right. Well, thank you, Kimberly. Thank you for coming in.
Thank you so much for having me.
It was a great discussion, and we will do this again in the near future.
Okay.
Thanks, Jim.
Thank you.
Thank you for joining us on this episode of Enlightened Wealth Strategies. We hope you found today's discussion insightful and inspiring.
If you enjoyed this episode, don't forget to follow and subscribe to our podcast. You can find us on YouTube, Apple Podcast, Spotify, or your favorite podcast platform to stay updated on new episodes.
Your financial journey doesn't end here. Connect with us online for even more resources and exclusive content.
Until next time, remember, financial enlightenment is is just an enlightened wealth strategy away.
Investment advice is offered through Bell Point Asset Management, LLC, 500 Demont Ranch, Parkway Building 700, Unit 700, Reno, Nevada, 89521. Additional information about Bell Point Asset Management is available on the SEC's website at www.advisorinfo.sec.gov. It is important to read our disclosures available at this link, www.bellpointasset.com disclosures. The information provided in this presentation is educational and limited to the dissemination of general information. This material is not intended to be a recommendation of any kind, investment, tax, or accounting advice. It does not constitute a solicitation to buy, sell, or hold a security or an investment strategy, engage in any financial transaction, and is not provided in a fiduciary capacity. The information provided does not take into account the specific objectives or circumstances of any particular investor or suggest any specific course of action. Investment decisions should be made based on an investor's objectives and circumstances and in consultation with his or her financial professionals. While the advisor uses reasonable efforts to obtain information from sources believed to be reliable, the advisor makes no representation that the information or opinions contained in this material are accurate, reliable, or complete. All information and opinions contained in this material are subject to change without notice. The views and opinions expressed are for informational and educational purposes only as of the date of the production or writing and may change without notice at any time based on numerous factors such as market or other conditions, legal and regulatory developments, additional risks and uncertainties, and may not come to pass. This material may contain forward-looking information that is not purely historical in nature. Securities offered through Fortune Financial Services, Inc., member FINRA and SIPC, Bell Point Asset Management, LLC, and Fortune Financial Services, Inc. are not affiliated. Past performance is no guarantee of future results. Investing involves risks. Principal losses possible.